welcome to this webinar on GDPR. We'll dive straight in. So what is GDPR? So that's a good start, start at the beginning. GDPR is the updated general protection regulations from the EU. It's effective from the 25th of May 2018. Although the ICO expects people to have made great strides by that date and be compliant or working towards compliancy. There is this still confusion around Brexit, but that will not affect it. It's been confirmed that the UK are very much adhering to GDPR. And as before, with the Data Protection Act, it really complies to organisations processing personal identifiable data. So that's what this is to do with. So if you think about your organisation and think what personal identifiable data you have and what you're doing with it, that is what GDPR is largely about. Okay, so in terms
of accountability, there are 6 principles. So first of all, you need to consider making sure that you process your data lawfully, fairly and in a transparent manner. And you can only really do that by making sure that you collect the relevant data that you need and that it's only collected for the specific purpose that you require that data for. It needs to be in your messages and your privacy notices. When you're collecting data, it needs to be explicitly clear, and you need to explain to your data subjects, to those individuals, your customers, what the purpose of that collection of that data is for. So you need to make sure that you keep it adequate, you need to keep it relevant, and that you only keep data for the necessary time that you are actually requiring it for that purpose. So making sure it's accurate and keeping it up to date is really important. So you might need to check with your customers to ensure that their data is correct. And at the end of the day, remember, only process data that's appropriate to the manner in which that you require it for, and maintain that security of your data. So what are the fines? Well, they're very well publicised regarding fines, as you may know or not, that the fines are 4% of annual global turnover for the breach of the 6 principles we've just been over. There's also 2% annual global turnover of breach of any of the articles under GDPR. On top of this, there's also other fines which you can be fined for as well. The ICO have said that if you have a breach of data, that they can also fine you. They'll also fine you for non-compliance with not following through a framework under GDPR. So it's really important that everybody follows and documents a process within their business. Also, you may want to consider if you have a data breach, how you're going to handle compensation and also legal costs on top of this. And the worst case scenario is if your organisation has a breach upon breach upon breach of releasing personal data out there, that the ICO do have the power to actually stop you trading for not handling personal data effectively within your business. So what are the 12 steps to compliance?
So, thanks Vicky. In terms of the 12 steps, we've actually got a slide on each of these. So this is effectively the framework that you need to become compliant. So we're going into more detail, but I just point out a couple of things. Obviously, making everybody aware within your organisation and getting senior board level buy-in is key. There may be some budgets that need to be assigned, etc. So this is a high impact, high probability risk if you don't have this framework in place. So it's about your board wanting to mitigate that risk and bring it down to low impact, low probability. So it's, as I say, it's really important that everybody's aware. One of the big things I wanted to point out on here is the subject access requests, because that's going to be the biggest reason why the ICO is going to be aware of your organisation, because obviously if you don't get your subject access requests right, people are going to complain, and they're going to complain to the ICO. Now, we've mentioned the word ICO a lot, That's the Information Commissioner's Office, and they are the supervisory authority in the UK for GDPR, so that's why we keep mentioning them. And then the second biggest reason to be highlighted to the ICO would be around data breaches. So again, that's something that we're going to cover.
So the first step in this process really is all about awareness. It's awareness in your organisation, first of all, about identifying personal identifiable data. So that might be internal data you have within human resources. It may be your prospecting data in terms of marketing data that you may use. And it's also data that you have day to day with operating with your customers as well. To handle this and to manage this, you may use or set up really a project team to help you identify where the data is, who's using it, what they're using it for, how long do they need to keep it for. So there's going to have to be a lot of training and awareness around this, specifically in your business, so that people understand what they're dealing with in terms of data and why they're collecting it and how they're going to process that data. So you might want to consider appointing a project manager to oversee this, or potentially use your DPO, which is your data protection officer maybe within the organisation. It doesn't have to be. But most importantly is that you really grasp this whole concept and actually create a project plan for it. Creating a project plan and actually writing it down is really important. It's something that the new GDPR regulation actually specifies, and something that if you are investigated by the ICO, that they will be looking to actually see. So this whole internal communication is really important. So how do you achieve this? Well, you can use something called the PIMS framework, and that's not your drink there. It is the Privacy Information Management System framework. Now, this framework you can use as your basis in your organisation to create policies and procedures of how you're going to handle personal identifiable data. So, for example, you should have in your business, if you don't already, a data protection policy. How are you going to keep your data safe and secure? You also may have information management policies, document and record control policies. All of these policies are basically there to explain to the organisation and the outside world is how are you going to do it, and following it up then with more detailed procedures of what and who's going to do what within your organisation. So use this framework as your basis for creating those policies and procedures. And there's lots of things you can find on the internet to help give you inspiration, advice on how to write some of these documents.
Okay, thanks. So in terms of one of those policies, it would be around communicating out to your data subjects exactly what you're doing with their data, and that's done in the form of a privacy statement. There's some really good ones out there. Ones to look at would be the BBC, John Lewis, IBM have a great one, as do Google. So there's a few there to have a look at and use as a template. But effectively, what you're doing with a privacy statement is you're saying to data subjects, this is why we're collecting your data. This is potentially who we're going to disclose your data to, and this is effectively being transparent, open and honest with them about what's going on with their data. That's the idea of a privacy statement. Then obviously you need to consider the individual's rights. So these are rights given to the individual around their data. So I can just run through them, but they're pretty self-explanatory. The right obviously to be informed, so that's if you're looking for consent, etc. The right to be informed that you're using their data. The right of access to that data, the right of rectification to keep it as up to date as humanly possible, the right to be deleted, the right to restrict processing. Although again, if there's legal basis for processing, some of these things can be challenged, but people have the rights, and there needs to be a process to get these rights considered, etc. So the right of data portability, that's about moving from potentially one supplier to another and making that as easy as possible. The right to object to you processing their data, and the right to have a manual process if there's an automated process in place. So, for example, a credit check would be a classic. If that comes back negative, you have the right to go to that organisation and say, I want you to go through the process manually with a human involved. Okay, so as I mentioned at the start, the data subject access request is the area where you're likely, if you get it wrong, to be highlighted to the ICO. So really important to get this right. Data subject access requests are now free for the data subject, so obviously that is likely to lead to increased requests as people are aware of this. Again, going back to training with your organisation, it's about how do you identify what a data subject access request is, because your customers aren't necessarily going to just send you an email with the subject header data subject access request. They can come in all sorts of forms, as you can see there. So it's and it's about identifying what one is and then having a procedure and a process to deal with that. They must be completed within 1 month, so that's 30 days. That's not working days, that is 30 days from the date that you receive the request. And you must validate that the data subject is the person they say they are. So there is a proof of identity required. It would be a breach if you didn't have the proper processes to vet the person that's asking for the data and it goes to the wrong person. That would be a breach on your part as well. There are, as I say, it's a big area, this. There are lots of probably questions around it that we can take at the end. That's absolutely fine. So move on.
So step 6 to 8 is all around the legal basis for processing data. So obviously you can have a legal basis for processing data on consent. So if you're using marketing material and somebody signs into your website, having your cookie policy there, being able to tick a box to see the privacy policy for your organisation, and being able to consent to them being marketed to, it's going to be really important. And as easy as it is to give consent, it's also as easy to withdraw consent as well. And that's something that your organisation may need to change, consider how you're going to do this. So also, the legal basis may also be upon a legal contract. At the end of the day, we've all got contracts with our customers. So we need to make sure that we adhere to making sure that we somehow incorporate GDPR within our contracts and understand who is responsible for what. So you may want to look at your contracts as well. Data subjects also have the right to ask for information regarding the legal process. So again, it comes back to being explicitly clear about who's got consent and why you're processing their personal data. So consent must be freely given at the end of the day, and there's also special rules around children. If you're asking children to consent to a process for processing data, then it must be in a language that is really clear and simple to understand. It's a very specialised area, and is one that you may need to look into further if you're dealing with processing children's data.
Okay, in terms of data breaches, this is around sort of notification to the supervisory authority, the ICO. So it's notification with 72 hours of when you discover the breach, and that has sort of no weekday times or anything. So if the breach is Friday evening, that's when the clock starts effectively. So you need to work over the weekend to sort it out. And what the ICO are after is all the information about the breach, really. You know, what's happened, if you know why it's happened, who's been affected, and all the information around what's happening, and also what you're doing to mitigate the breach, what your processes are. So obviously they'll want to understand those, and probably at a later date come in and look at those more rigorously. As I say, it's really about communicating that reach. One thing to point out as well is if you don't think you can get all the information to the ICO within the 72 hours, then let them know that you can't get that information to them early. Don't wait until the 71st hour to tell them that you're going to need more time. Do that within the first day, ideally. Maybe it's clear that you can't get it. It's all about being, again, open and transparent and working with the ICO, not seeing them as the enemy, but seeing them as somebody who can effectively, potentially help. Okay, in terms of data protection by design, there is a form called a DPIA, which is a Data Protection Impact Assessment. This is something that the ICO want every organisation to do at project level. So if there's a project coming up in your organisation, it involves personal identifiable data, then a DPIA is required. And again, what that does is it documents the life cycle of the data. So it basically says, why are you collecting this data? What data are you collecting? What are you going to be using it for? And so on. So it clearly sort of steps out every process that you're going to be doing with that particular piece of data. So really important. And also you can retrospectively do it. So if you go back to step 2, where you're looking to map out what you're doing with data within each department in your organisation, do a DPIA. So have one for HR, for your staff, have one for the marketing team, for people that you want to prospect to, have one for customers and so on. So you've got one for sort of every area of data that you hold. It would be best practice to retrospectively go back. But moving forward, data protection by design should be the first thing you think about when a project comes up. Is there personal identifiable data involved, and do we need a DPIA as a result? In terms of a data protection officer, do we need, too far there. Do we need a data protection officer? Good question. You do if you're a public body, so you have to have one if you're a public body. You have to have one of your core activities involve processing personal data. Also, if you're processing data on a large scale, although the ICO don't actually define what a large scale is, so that's quite helpful. And if you're doing sensitive personal data, so that's the child data that we've already talked about, healthcare, biometrics, there's a few others, there's a list, there's an article around sensitive data that you may be collecting. But the main two really are healthcare, anything to do with people's health, and anything to do with child data, then you'd need a DPO. And the DPO should report directly to the board. They should have anonymity, so effectively they can't be blamed if things go wrong. They're there to advise and to make sure you adhere, not to be a scapegoat, basically.
So step 12 is all about international transfers of data. Now obviously if you're transferring data within the UK, that's fine. If you're transferring data within Europe, again, you should be fine, because we're all singing from the same hymn sheet effectively. We're all complying to GDPR regulations. However, if you're then transferring data in your organisation to other countries outside of the EU, you're going to have to look at it carefully and take steps to make sure that you're transferring data securely and adequately, and put appropriate safeguards in place to do this. There are binding corporate rules that can apply to this. This is again a very complex area, so if your business actually is transferring data across international waters, then please take a special care and attention to make sure you're complying with GDPR under this area. So in summary, Steve?
Yeah, to finish up, some of you may be pleased that's happening, but no, to finish up, if you have a plan, do, check, act, review and improve model, that's really going to help. So obviously plan, make everybody aware, the training, appoint a DPO if you need one, make sure the board are on board. Get all your policies and procedures in place, that's your PIMs and your DPIAs, etc. check all your policies and procedures, so go back and check and review those. Act, obviously, do all this stuff because it's 10 months away now, so the clock is ticking. Review, obviously, we don't have any case law at the moment, really, so as people are fined, keep an eye on why they've been fined, and then go back and review your procedures and policies and make sure that you're protecting yourself and reducing the risk. And that's obviously a continual improvement sort of loop cycle, really. So hopefully that helps. We'll go on pause now for a little while, and then we'll take some questions, if that's okay.
Hi, so we have a question around ISO 27001 and how far does that accreditation go towards GDPR? Well, ISO 27001 does apply. It helps quite a bit. It doesn't go to say that you are then compliant with GDPR just because you have ISO 27001. And if you're not aware, ISO 27001 is international standard for information security management systems. So it goes some way because it covers some of the data protection policy statements and policies that you need to put in place across your organisation and how to handle data. It goes some way to ensuring that your networks are secure, that you have good processes in place, but it doesn't mean that by having it that you are GDPR compliant. It only goes partly way through because there are other things on top. Hence the reason why the PIMS framework is a really good model to work with, because it covers, between PIMS and ISO 27001, it covers everything. Another question has come in around biometric datas and scanners. So this is quite relevant because I don't know if you, Steve, saw on the news this morning about biometric data being used by one of the major banks,
Okay.
where they're using it on an Android phone and actually doing retina scans for
Okay.
your for being able to log into your bank. So biometric data, I think, is going to become part of our world, everyday world, isn't it? So, you know, I think it's a very sensitive data. That's the first important thing I think to point out, is that how you handle that sensitive data, it needs to be very carefully managed. So the storage of data and the encryption of data, making sure that it is safe and secure, is going to be probably the biggest security risk of all. So and making sure that it is safe at the end of the day is a big part of that.
So there's another question around cyber security. What about cyber essentials? Is that good to adopt? Absolutely, it's great to adopt cyber essentials. It depends on the level and the size of organisation you are. So everything has to be proportionate. So if you're obviously a small organisation, then it's the cyber essentials is probably a good framework to work to. If you're a larger organisation, you may want to look at sort of other cybersecurity frameworks, NIST, etc. I know that's a US one, but yes, it certainly is good practice to. It's all about protecting that data really, and avoiding a data breach, and also having the technology and the means in place to identify a data breach. So we've seen quite a few breaches out there recently where organisations weren't aware that they'd been breached for over a year. Now that's going to reflect badly, because obviously your 72 hours is when you discover the breach, but obviously when the ICO looks into the breach, if it's been in your organisation or it's been affecting personal identifiable data for a long time, that obviously isn't going to reflect well. So it's all about having threat detection as well as prevention, I think. So yeah.
And around another question's come in around actually holding on to data and who is responsible for what data. So for a good example here is around invoicing. We have our clients are on our server with websites which hold their customer data. So who is then effectively responsible for that data?
Yes.
Do you want to answer that, Steve?
Well, that is a good question, obviously, because in some cases where we're looking after your data, it's in our data centre. You are the data controller, so you are telling us what you'd want to do with that data, and in some cases we know for maybe the processor. So again, in those situations, we'll be updating our contracts to reflect that. And we'll also expect you to have protection measures in place, because obviously these are optional services from Node 4. You don't get your data protected as standard within our environment. So it's about having the appropriate optional security in place, really. And obviously we would risk assess that, because obviously if it impacts ourselves, then we need, this is the whole point of these webinars, really. It's about education, it's about working with you to make sure that we're kind of working together to not get anywhere near the ICO, I guess.
Yeah, and I think it also, with that question, is important to understand in every organisation, you know, your organisation, most importantly, is understanding who's got control of that data, who is the controller, so who's actually inputting it, looking after it, etc. If you're then storing your data somewhere else, with a data centre, etc., then obviously that is then going to the processor. They're just holding it, they're safeguarding it, they're putting it in a secure environment to help protect and make sure that your data is being looked after in a secure way.
Well, they're not as standard. It depends. So it's your responsibility to make sure the controller is doing those things.
Yes.
And
that's why there's a clear distinction between controllers and processors.
Exactly.
So understanding that, who's got control of that data, and then where you're storing it and keeping it is part of that process. So understanding that is really important. I think that's all the questions actually that we've dealt with. So unless there's some more to come in, but for now I think that's it.
Yes, there was a few more around encryption and a few others, but I guess we could go on for a while. But in terms of encryption, I'll maybe just cover that final one off. If you encrypt data, then obviously that is best practice. There is an article around security, Article 32 I think it is, and it mentions pseudonymization and encryption. So it's basically saying that if you encrypt your data and it remains encrypted, it's effectively not personally identifiable anymore, so therefore sort of comes outside of GDPR. However, obviously when you encrypt data, you have to be able to unencrypt it to read it, and there will be times where that data is vulnerable, so the other safeguards still need to be in place. It's not a get out of jail. There are very clever hackers out there that can see that you know, they know when your data is unencrypted and they can still access it. So it's absolutely best practice to do, but it's just a part of a layered security defence. So I think that'll probably end everything for now. If there's other questions, we'll absolutely get back to the individuals that's answered them. Thank you very much.
Okay, thank you. And of course, this will be on the Node 4 website. If you have missed anything today or want to recap on anything, it will be available on our website as well.
Brilliant.
So thank you. Thank you for listening.